Today, we're just going to do a full overview of J1 waivers, and then we'll go into question and answers. So there's a variety of different types of J1 waivers. We're going to focus on the hardship waiver and the no objection waivers and talk a little bit about the Conrad 30 waiver. Then we're going to talk about timing. We're going to go into the expedite process and when you should apply. Those are some common questions that we get, and then we'll open it up to Q&A. So there's a few different types of J1 waivers. One of the most common ones is the no objection waiver. This is where you get a no objection statement from your home country. You apply with the Department of State. These waivers are good if, one, you're not a physician. If you're a physician in graduate medical training, you're not eligible for a no objection waiver. So sometimes we get physicians asking us, well, can I do a no objection waiver? It is a more straightforward and fast process, but the no objection waiver in that situation doesn't apply. Also, if you have U.S. government funding, it's very difficult to get a no objection waiver in that situation as well. And your home country has to always also be willing to cooperate and issue the no objection statement. So one of the things that, if you're interested in that option, is you can connect with your embassy in Washington, D.C. is where most of them are, and ask them if they are willing to issue a no objection statement. Some of them are, and some of them are not, and some of them have some unique requirements that they want met. That moves us on to looking at the Conrad 30 waiver if you're a physician. So Conrad 30 waiver has pros and cons. What that is if you're working in a state, every state has 30 spots available to you if you work in an underserved area for 3 years, and you'll be working in H-1B status. So there's some pros and cons to it. You don't get the J-1 waiver actually until you complete the 3 years. So you can't move on to the green card process until you're done with the 3 years. You're also working in an underserved area for 3 years. So some physicians don't like to work in that specific area. They don't like the lack of freedom. It is hard to change employers once you are working for that facility. It is possible if there's extenuating circumstances. Extenuating circumstances might be something like the facility closes down, they're violating the terms of the contract, but otherwise it's restrictive in that front. The positives are, if you're applying for a state that doesn't typically fill up the 30 spots, if you do everything right, there could be a good chance of approval depending upon the state. And of course, if the application is prepared correctly. But a lot of states do fill up. Some of them are first served basis. Some of them are devoted primarily to rural areas. So it's very state dependent. And I would advise you to look at the states that you're applying for if you're looking at a Conrad 30 waiver. The alternative to that is to apply for a hardship waiver. For a hardship waiver, and we do many of these in our firm, we're looking at exceptional hardship. So exceptional hardship is what is called the qualifying relative. Believe it or not, people sometimes make this mistake, and I've seen it in my consultations. They don't know who the qualifying relative is. So I want to make sure that's clear. The qualifying relative has to be a U.S. citizen spouse or lawful permanent resident spouse, or U.S. citizen child or lawful permanent resident child. You have to show hardship to the qualifying relative, not to yourself as the applicant. The government doesn't, unfortunately, care about the hardship to you, the applicant. They care about only hardship to the qualifying relative. So then the question is, well, what is the hardships? Like, how do I demonstrate exceptional hardship? So there's a variety of ways that exceptional hardship can be met, and that really just depends upon your unique life circumstances. So a lot of times, for instance, let's say if you're a doctor, there could be career hardship. If you had, let's say, this happens in many of our cases, where if you're here in the US, you are on residency, and then if you had to go back, for instance, to India, you'd have to start over in respect to perhaps your licensing or whatnot. That might set you back a year. So that could be a form of career hardship. Financial hardship as well. Of course, you're not going to be making the same type of income that you would in your home country, and you may not be able to support your family. And then any type of health hardship, if you can't get the same standard of care that you would get in your home country. We often talk about that. Melissa, do you want to talk about some of those examples of some health hardships that we've had for clients?
Yes, definitely. So with medical hardship, when we're talking medical hardship to the qualifying relative, it's whether the conditions in the home country would make their condition worse, or whether they wouldn't have access to the specialists or the medications that they need. The other type of hardship that we do, so generally we're looking, of course, to hardship to the American or LPR parent or child, but there's also sometimes these arguments that we're making where we're talking about hardship to the J1, him or herself, and how that would affect a child. And the most common example of that is when we have a J1 who gives birth in the US and is struggling with postpartum depression, then we argue that because the J1 has this condition, if she were to leave the US and relocate back to her home country, she wouldn't have access to the treatment she needs, and she wouldn't be be able to care for her child. So that is an example. We're looking exclusively to exceptional hardship to a U.S. citizen or lawful permanent resident parent or child, but immigration will also consider hardship to the J1 insofar as it affects the spouse or child.
Yeah, thanks for bringing that up. That's an important point, because in the situation where you have a child and your hardship is based off of your U.S. citizen child, in that situation, we do look at the parents and how their hardships funnel down to the child, because of course, your child is dependent upon you. I think Melissa gave a great example of that. And then we also look at mental health hardship. So in that situation, for instance, if your U.S. citizen spouse has anxiety, depression, they've been seeing a therapist, a psychiatrist, we talk about that as well. What is found to be the most beneficial in terms of credibility in looking at the mental health hardship and how USCIS looks at that is ongoing treatment. If you just have an evaluation in and of itself, they can look at that as just being self-serving. The ongoing treatment builds the case that you actually do have the mental health hardship, which is if you have depression or anxiety, you're probably seeing a therapist already or need to see one, and it is something that needs to be treated. Anything else you want to add to that, Melissa?
Well, the only thing I wanted to add was just that, immigration considers that mere sadness is not enough. So there's an inherent level of sadness to being separated from your spouse, and that's not enough. So immigration, to have a successful argument for exceptional emotional hardship, we really do need that American or LPR spouse to start seeing a therapist, a psychologist, a psychiatrist, to really show that this is not mere sadness. This is someone who, even at the prospect of being separated from their spouse, is very anxious about the situation and is feeling depressed, maybe can't sleep well anymore. That's really what immigration is looking for. Mere sadness is not enough. And with these hardship cases, you rarely win them on one factor alone. USCIS is looking at the totality of the circumstances. They're looking at all of the factors. And when we consider all of the factors together, do we rise to the level of hardship? So there might be financial hardship in the scenario where you relocate to your home country. There's also emotional hardship at the prospect of being separated. There's a country condition hardship. All of these things together. Maybe one factor in and of itself is not enough, but maybe all of these factors together will rise to the level of exceptional hardship. And for us, we really try to cover as many bases as possible. We really try to address every possible argument because, again, USCIS is looking at the totality of the circumstances.
Yeah, that's a great point, because a lot of times clients will ask, should I just focus on this hardship or that hardship? And what we're doing when we prepare our legal brief to USCIS is we're creating really a narrative. We're explaining your story so it can be understood, because you don't get the opportunity to talk about all of the hardships that you face. By talking about all of the hardships, well, it's not just depression and anxiety that I'm going through, but I'm also not going to be able to get the job that I'm going to get and be able to pay the bills and support two families. And when you put all of that together, that's what makes a real powerful case. Rarely do we see a case where it's just one form of hardship that qualifies and meets the requirement of exceptional hardship. But it's putting all these together that really creates that.
And the last thing that I wanted to mention before we move on is just that every case has just really particular circumstances. So in some cases, we might be arguing that the American spouse cannot continue their education in the home country, or the American spouse would suffer career hardship if they went to the J1's home country for 2 years because they would be 2 years out of practice. Or, there's just so many different types of hardship that you can argue, and it really just depends on the person's circumstances, that family's circumstances. Sometimes we have J1s who are providing medical insurance for their American spouses, and if they were to leave, their American spouse would lose their health insurance. There's just so many arguments that could be made. It really just depends on the person's circumstances.
Hope this video serves you. I want to thank you for taking the time to watch this video. By watching this video, you're bettering yourself. By bettering yourself, you're bettering your family. And by bettering your family, you're bettering the world. Thank you. Bye for now.